All right. Hello, everybody. Welcome. Thank you for joining us today at our session presented in partnership with Gallagher, one of the leading insurance brokerage and risk management and human capital consulting companies in the world. Today, our presenters will review how habitability lawsuits are severely impacting affordable housing operations in California, as well as best practices recommended to prevent and defend such claims. Our speakers today are Robin L. Rosner, Area Vice President and National Director of Affordable Housing Nonprofit Practice at Gallagher, and Sarah Gibson, Risk Control Consultant at Gallagher. Thank you guys so much for joining us today. And Robin, the floor is yours.
Great, terrific. Thank you so much, Alan. Well, I'm just excited to be here with all of you. If any of you are familiar with our longstanding and valued partnership with SCAMP, we're so pleased to continue supporting you with educational resources, which we've been doing for a few decades now. And then just thrilled to help all of you learn a little bit more about what is impacting insurance costs out there, and in particular, these areas of habitability claims, and how it can cause problems down the road for your portfolios and individual locations. Also with us, as Alan mentioned, is Sarah Gibson, excuse me, on our team. So Sarah, I'd like to give you an opportunity to say hello.
Hi, everyone. Yes, my name is Sarah. I am a risk control consultant with Gallagher. I predominantly work with affordable housing clients, and really the goal is to try and identify risks that can potentially lead to claims on the insurance policy, as well as losses for the organization, and then coming up with solutions to either eliminate those from occurring or mitigate them, even if we can't eliminate them entirely. And certainly habitability claims have become an increased exposure, especially for residential landlords out in California, including affordable housing. So I am excited to have this opportunity to speak with you guys, along with Robin, to talk about what they are, so you can kind of understand what the risk is, as well as what we recommend doing to try and mitigate these claims from occurring.
Great. Thank you so much, Sarah. And I believe during the course of today's session, there will be someone monitoring the chat, which certainly we're happy to take questions as we go. We've also reserved time at the end, and we're going to put our thinking hats on at the end as well to talk about what other ideas you may have about helping to mitigate and avoid these kinds of claims. So with that, let's jump into what habitability claims actually are and provide you some definition. So this is, if you walk away with today's session with anything, it will be, wow, a lot of things can fit under that umbrella of habitability. And you're going to learn, and you will hear this from us repeatedly, to document everything as you go through this process if you do experience a claim. So simply put, a habitability claim comes from the idea that a plaintiff has alleged the landlord has breached the implied warranty of habitability. And I would imagine pretty much everyone is familiar with this very basic concept, the implied warranty of habitability being that you are providing a unit, a rental unit, in a condition that is fit for the occupation by a human being. So it has to be livable, essentially. It's pretty simple on its face anyway. The difficulty is, though, that there's no actual concise standard or statutory definition of the term habitability. In other words, the law doesn't really give us a super clear line threshold or measuring point. So landlords have to substantially comply with building and housing code standards, which can change and vary from jurisdiction to jurisdiction, and can be a bit of a moving target. So what we're going to, of course, give you today is some ideas on how to at least be ahead of that as much as possible. But in the grand scheme of things, the idea of habitability is providing that unit which is basically livable. Now, every unit must generally have the items that we have in these next two slides to be considered livable or habitable. But this is not the exhaustive everything under the sun list, because as I said, that such definition doesn't really exist. What we're doing is we're pulling together the information that we've seen alleged from claims, the information that is or sometimes even is not specifically described in the statutory language, but maybe implied, to give you at least the best possible checklist to start with. So, of course, waterproofing and weather protection. You should not have deteriorating plaster, exterior walls, roofs, ceilings, foundations, floors, doors, or broken windows. In other words, the building needs to actually keep the weather out. Pretty simple, but not always the most feasible if you've got a difficult building or you've got vandalism issues that may come up, or you perhaps have some renovations that need to occur and haven't yet gotten to that point. So when you get to the site-specific issues, you may have some things that pop up that haven't yet been addressed or will be addressed in future rehab or something like that. Of course, each unit must have working plumbing, gas facilities, you know, your basic utilities, water, hot and cold running water. Must have a bathroom, essentially, water closet, lavatory, or bathtub shower, heating, ventilation, electrical lighting, and wiring. So kind of the basics. And then on the next slide, we have a few additional items. They must also be kept clean and sanitary and free of trash, rodents, or vermin. This can be difficult. We have situations where the resident or residents are the ones who occasionally will bring in the unsanitary conditions, including insects. I would imagine we will have some questions by the end of today about bed bugs, and that is often something that comes up here, as well as rodents. But that is the idea, that the units be kept clean and sanitary, no mold, adequate trash receptacles. So having the ability to keep that unit clean, certainly keeping the common areas clean as well. Floors, stairways, and railings in good condition. A mailbox for each unit must be provided, and it must lock. Now you may say to yourself, well, how is a mailbox going to really impact the living condition, the habitability of the unit? Well, this is one of those things that is within the code language or has come up in other claims, just like a hardwired operational telephone jack. Some people on this session may not even really know what that is because you've used a cell phone for most of your life. But a hardwired landline is actually also required. You should not have any dampness, free of fire hazards, and code compliant fire suppression systems. For example, sprinklers, or if there's a commercial kitchen within the building, that kind of thing. So again, this is not an exhaustive list, but these are the things that we have seen rise to the definition of habitability, what is required, and there are likely some things on this list that would surprise you. We're going to next talk about the allegations, and I'm going to turn it over to Sarah.
Thanks, Robin. So now that we've kind of gone over what habitability claims are, what the definition is, we did want to go through what these lawsuits or claims are actually looking like. So by and large, the types of lawsuits we see are ones that we refer to as boilerplate lawsuits, which means that we're seeing the same attorneys file the exact same lawsuit on behalf of plaintiffs from multiple buildings and against different types of affordable housing clients in different areas throughout California. So what it looks like is actually that they just copy and paste the complaint each time they file it, and then they'll just change the plaintiff's names, the location that they're suing, and then the dates that they're alleging these inhabitable conditions were at the building. And typically what these complaints do, I mean, there are some nuances between the different plaintiffs firms, but what they look like is they just say that the plaintiffs lived in the building from X year to present or X year to X year. And then they will say that either the owner and or the property management company failed to, and then they'll list the entire code section. So we put some examples up here on this slide, such as the first one I'll read off, which is maintain the premises from accumulations of trash and debris as required by LA Civil Code 11-1610 and LA Municipal Code 91-8104 and other applicable laws. So they'll not only just do any state requirements or federal requirements, they'll actually go to the county and the city as well, get all of the building codes that would possibly apply to that building. They'll list out that entire code section, and again, just say that the owner or the property management company failed to comply with that code section, which can be very difficult because, as Robin mentioned, it is a very long list. I mean, she went through a couple of them in the slides prior, but it's far longer than that, and it becomes really difficult to defend, because especially with lawsuits that have multiple plaintiffs, because you don't know which plaintiffs are alleging which conditions, whether it was inside of the unit or was in the common area of the property. I mean, it's so broad that it's hard to even really attack and be able to defend it at first. And we have to go through a lengthy discovery process, which for those lucky few out there who haven't been through any litigation yet, the discovery process is where the plaintiffs and defendants go back and forth to get information from each other. So sometimes it's written requests for documents, sometimes it's questions that get asked that they have to respond to in writing, and then other times it's actually having the plaintiffs or the defendants go to depositions and get in-person live testimony for them, either transcribed or recorded. And for these boilerplate lawsuits, I find a lot of time they start because the plaintiff attorneys are actually recruiting tenants or they're soliciting tenants to file the suit against the property owner or the property management company. So some of the common forms I've seen are they'll actually go outside of buildings and post advertisements saying, have you ever seen a bed bug? Have you ever had a leak in your apartment? Have you ever seen trash in your building? They'll ask a bunch of questions. If so, call this number. You could get up to, $10,000+ if this has happened. And then that's how they'll start recruiting tenants at buildings. It's not even necessarily that a tenant is approaching them. Other ways I've seen is that a plaintiff's attorney will get 1 or 2 tenants on board. Maybe if the tenant did go to them to complain, or perhaps, they were doing some advertising and, got a tenant to come in that way. And then they'll have that tenant go around the building and start recruiting other tenants to join the lawsuit. So those are a couple of ways. A third way I've heard of is tenants actually receiving phone calls from attorneys asking them that same set of questions, if they've ever seen these issues inside of their units or in the building. And then, if so, letting them know that they could get some type of monetary reward if they were to file a lawsuit against their landlord. And then on the next slide is the other type of claim that we see. It's not as common, but sometimes, there are actual issues going on with the unit, whether it's actual or perceived by the tenant. The tenant will go seek legal counsel to see what can be done to rectify the situation. And then there'll be really specific lawsuits about just, 1 or 2 issues. The ones I have seen that are issue specific have revolved around rodent infestation inside of units, as well as issues with mold and then leaks with plumbing fixtures and things like that. I will say that a lot of property or general liability policies, actually exclude coverage for claims solely from mold. So I have seen a few instances where there has been mold in a unit, the tenant gets an attorney, they file a habitability lawsuit just for mold, and the insurance company actually denies coverage because there is no coverage for claims arising from mold. Usually those attorneys aren't as experienced with habitability claims because the ones that are experienced know that that's a common exclusion, and they usually don't include it, or they include it with, a handful of other complaints. So I wanted to point that out there just to let you know, you should check with your insurance agent to see if there are any type of exclusions like that on your policy. But also I wanted to let you know, if you do receive a claim like that and you do get coverage denied, I think in 90% of the cases, what ends up happening is the plaintiff's attorney will file an amended complaint, and they'll allege other habitability issues that they know will trigger coverage once they find out that no insurance coverage applies. So if you find yourself in a situation where you get a habitability claim that's just surrounding mold and it gets denied for coverage, if that attorney comes back and files an amended complaint or adds on to their complaint to have a broader scope of allegations outside of mold, at that point, turn it back into your insurance carrier. They will reevaluate for coverage and see if any coverage is afforded now that they have added additional allegations to potentially trigger coverage. And now I'm going to turn it back over to Robin, who's going to talk about the damages that plaintiffs are alleging they suffered in the lawsuit as a result of these habitability issues.
Great, thanks, Sarah. So I think from these last few parts of our discussion, you all can see that habitability claims are painted with a very broad brush. And certainly there are circumstances where conditions within a unit may rightfully so create or lead to a claim. If there is deferred maintenance, or there are situations or circumstances within a unit that just have not been handled or have been difficult to mitigate, there is definitely a time when a legitimate claim comes in, and of course, it should be handled as such. But unfortunately, there are a lot of fraudulent areas of these types of claims. We see it all the time. And many of these claims are driven, not exclusively, but a great deal of them driven by the attorneys using these as a revenue source because of their ability to collect attorneys' fees, which we'll get to in just a moment. But in the meantime, the allegations are going to describe all kinds of harm, such as what we have described here: illness, physical injury, mental distress, emotional distress, discomfort, annoyance, anxiety. These are not necessarily things that are just automatically defined and insured by an insurance policy. There's a lot of room for interpretation here, much as there is room for interpretation with the various health and safety codes that we cited a moment ago. Additional damages, which are on the next slide, include allegations of things like loss in value of the lease, personal property damage, out-of-pocket costs to the plaintiff, medical expenses for both the physical and mental ailments, some of which are very difficult to actually prove or disprove, especially the mental ailments, lost income and lost future earning capacity. Additionally, many cases will seek pre and post judgment interest, so they just want to, continue to tack more money onto the value of that judgment. But in the greatest sense of, shall we say, difficulty with this claim, with these types of claims, it does come to attorneys' fees and costs. In particular, we see plaintiff attorneys dragging these things out, trying to call for depositions from everybody under the sun, and they're racking up their costs because they're going to seek recovery of those costs. And Sarah's going to just give a little more insight on that because she does spend a great deal of time actually auditing through the costs on these claims.
Yes, and not every type of lawsuit are the plaintiff attorneys allowed to claim their attorney fees from the defendants, but per California Civil Code, this is one of the types of lawsuits where they can claim those fees. And part of the reason it's so dangerous is because if a claim goes to trial, for example, and they're alleging the entire code section, and plaintiffs are given any type of award, even if we're able to successfully defend 99% of the claims, there's only one code section that was found violated. If the jury even awards the plaintiffs $1, then the plaintiff's attorneys are going to be able to claim their fees and costs. And what's more concerning as a defendant in these lawsuits is that in the state of California, plaintiff attorney fees are not insurable. So even if we went to trial, we prevailed on 99% of the issues, only $1 was awarded. Unfortunately, your insurance carrier can't cover those plaintiff attorney fees, and you will be on the hook for 100% of those costs that they are going to claim. And most plaintiffs' attorneys know this. They know that their cases are mainly attorney fees cases, and they do use that to their advantage when negotiating settlements. And that's another reason why they want to get as many plaintiffs as they can into their lawsuit, because, well, one, you have to settle for more plaintiffs so the value can go up. But as Robin mentioned, they're going to do everything they can to send out as many written discovery requests, get as many depositions on calendar, even doing, independent medical examinations for all of their plaintiffs. And as anyone knows who's worked with attorneys, they usually bill for every 6 minutes of work. So if there's 100+ plaintiffs, which we have seen in some larger buildings on a couple of claims, they're not just billing one, for one plaintiff, they're billing for all 100+ plaintiffs. So these can rack up pretty quickly. And on the next slide, I am just highlighting a couple of habitability claim examples that will help highlight that issue. So the first one I wanted to highlight was a habitability claim that was actually settled pre-litigation. So a lawsuit never got filed. What happened is some tenants were experiencing issues in their units. They actually reported it to the Department of Health. There were some issues found. Issues did end up getting corrected within the statutory time frame, but they still went to seek an attorney to get compensation. And that attorney sent just an attorney letter of representation saying that they, represented these tenants in regards to the issues that they experienced in their unit, and that they were demanding $200,000 to settle them. And in exchange for the $200,000, they would not file a lawsuit and, release the owner and the property manager from any liability, and promise not to, sue them in the future for those unsanitary conditions that they found in their unit and the pest infestation that they had. And what happened is because there were some issues, the insurance carrier decided to entertain doing, an early mediation. And in talking with the attorney who represented these clients, they actually admitted that this was largely an attorney's fees case, because while they could show and prove that there were some issues with the units that their clients were living in, what they had absolutely no proof of was any medical damages, any lost wages, really any type of monetary damage at all that these plaintiffs suffered. So there was no, because sometimes if the unit is in really bad condition, the plaintiffs may be able to prove that they, maybe their furniture deteriorated, or they had some other business personal property that got damaged. There may be even physical injuries if something broke and hit them, and they got physical injuries that way. Or if it was an unsanitary condition, a lot of times you'll see breathing issues and other physical ailments like that pop up. But again, in this case, there were no damages that they could claim. And the attorney flat out said that. He said he knew that. He said he knew it was an attorney's fees case, but he was one of the top bed bug attorneys in Los Angeles County. He had a very good track record at winning cases. So the insurance carrier did not want to risk litigating this claim and having him start racking up plaintiff attorney's fees. And they ended up settling for around $75,000, which comes out to roughly $18,750 per plaintiff, because there were 4 plaintiffs total. And the total cost incurred for that claim ended up being around $84,000. And for those not as familiar with how liability claims work when covered by an insurance carrier, there's the actual amount that's paid out to the claimant, whether that's to settle the claim or to reimburse them for any type of damages that they submitted. But then there's other costs that get incurred. And for these types of claims, they're mainly for defense fees, because we have to hire a defense attorney to come in to do an investigation, to litigate the case, to represent and protect your interests. And so the total cost incurred actually includes both what was paid out by the carrier to settle the claim, or to pay out to the claimant, but it also includes what they had to pay to defend and handle the claim. So that's why there's 2 figures there. And then the second claim, to show you in contrast to the one that was settled pre-litigation, is a claim that was actually a boilerplate habitability lawsuit. It was originally filed by 32 plaintiffs. Throughout the course of litigation over time, 9 additional plaintiffs had been added prior to when the case settled. And for this one, again, there was no proof, that there were even any issues really at the building, let alone any damages. But the insurance carrier did want to go through the discovery process to see if we could get more information to fight this claim if possible. So they did go through that lengthy discovery process that we discussed earlier. And this one did end up settling for less per plaintiff because we were able to make the argument that they don't have any damages that they could claim, that there really weren't any severe issues with the building. So it actually settled for around $10,000 to $14,000 per plaintiff. But with the number of plaintiffs that there were, which in the end ended up being 41, that ended up being just over $500,000 to settle it. And for this one, when it finally did get to the mediation phase, the initial demand from the plaintiff attorney was $1.5 million. And they told the insurance carrier and defense counsel that only $500,000 of the $1.5 million was going to be for damages that they say the plaintiffs had suffered. Not that they could substantiate $500,000 in damages, but they said that they're claiming $500,000 in damages. The other $1 million came solely from plaintiff attorney fees. So that was, nearly two-thirds of their total demand was just for plaintiff attorney fees. So when we say these are attorney fees cases, that's what they mean. And then you might notice on the slide for the total cost incurred for this claim, it ended up being over $900,000. And that's because almost $400,000 got spent on defense expenses to defend the claim, to respond to those written discovery requests, to take those depositions, to attend the mediation. So that's a significant chunk of change that was spent out in defense costs. So if you do end up having, one of these habitability claims and lawsuits and the insurance carrier is covering it, the insurance carrier does have the sole right to decide how the claim is handled because they're the ones ultimately cutting the check and financing the risk. And you may find, even if you feel that the claim is fraudulent, that they may want to be settling this quicker. And that's not to say that you can't push back on a claim or fight it. And there is certainly a lot to say about fighting back on a claim, because if you don't fight back and you just cut a check to the plaintiffs right away and they can't prove there were any issues or any damages, then what's to say they're not going to go talk about that around the building and other tenants are going to find out, or even tenants on other properties are going to find out that all they have to do is go to this attorney, file this boilerplate lawsuit, and then they're going to get a check in the mail. So there are times where it is beneficial to fight back on these claims and to just prevent another claim from occurring. However, there are other times where the insurance carrier may say, there are some issues and we really think we should settle this early. And so I just wanted to give that context. And the reason the carrier may want to do that is simply because they're going to end up incurring so much in defense expenses for a claim that's likely ultimately going to settle. Because in general, I think it's almost 98% of civil cases settle before they go to trial. So it's very rare for any case to go to trial. But one of the main reasons, again, that they don't want to take these cases to trial is because those plaintiff attorney's fees aren't covered. So going to trial is going to be a huge risk for you guys as the owners. And they certainly don't want to put that risk onto you, unless you want to take that risk on. So I did want to just provide that context and kind of show you guys how these are plaintiff attorney's fees cases, and then also, what the cost of litigating these claims can be. And with that, I'm going to turn it back over to Robin, because she's going to talk about, as you can see now, these cases can be very expensive and you can get those total costs incurred to be very high numbers on your loss run. So she's going to kind of talk about what the impact of those claims and lawsuits can be on your insurance.
Yeah, and I also see we had a couple of questions come in, so I'll address those as well. But just to kind of tie a bow on this particular point and illustrate Sarah's example there of the $927,000 loss, let's consider that compared to what the annual insurance premium was for that particular portfolio. For the sake of round numbers, let's just use $100,000. Let's say it's a small portfolio maybe 8 or 10 buildings, and it got hit with one really bad habitability claim, and that claim paid out $927,000 in costs and settlement and all of that, as she explained. Well, the insurance company is looking at that cost benefit analysis going, they pay us $100,000 a year in premium, but we just paid out 9 times that in one claim. Then we get to where things really turn sideways in terms of continuing your insurance program for the property, because it becomes a much greater challenge if there's a very large loss in this habitability area. And we'll talk about those additional impacts in a moment. But I just wanted to kind of give that for a point of illustration. The carrier is going to consider how much premium have we taken in on this account versus how much we've paid out in claims. And that's going to drive some of their future decisions about providing insurance on a go-forward basis. Now, the first question that came in, can tenants sue for money they've paid as rent based on a claim that the fair market value, a fair rental value, was below what they've been paying? Absolutely. I don't see why they probably wouldn't come up with that allegation. They're going to say, hey, the unit wasn't habitable, you didn't meet all these standards, therefore you're going to owe us a refund. So that certainly could be on the table. The second question, what about when we limit the attorney fees in the lease agreement? That's definitely a good risk mitigation strategy. It's not airtight, may be deemed unlawful, or that was not a proper acknowledgement by the tenant in the document, or not a right that they are actually able to give up. But it's definitely a start. Sarah, did you want to weigh in on either of those about loss, the lower rental value, or limiting attorney's fees in the lease?
Sure. So for the first one, the lower rental value, there is a code section in the state of California, or code requirement, excuse me, that says if there is a citation or violation found on the property and it's not fixed within a certain time period, and I suppose we talked about that on a later slide, that a landlord can't charge rent to the tenant. And so that applies whether it's for a for-profit or nonprofit housing or affordable housing. The code section doesn't apply to a specific type of residential landlord. So if there was a habitability issue that wasn't fixed within the time frame, and the tenants can substantiate that, then yes, they can, per that code section, claim that they should not have been paying rent because it says that rent shouldn't be charged in that scenario. And then for the second question, yes, as Robin mentioned, you can put that into a contract. There are certain state laws that prohibit how much you can limit someone from being able to spend on those fees, but how you even limits to the indemnification. And then if you were to do certain types of clauses, so for example, a common one is arbitration agreements, there's like really specific things that have to happen in order for those agreements to be deemed valid. I am not an attorney, so unfortunately I can't advise on how to make sure that those agreements are valid, but my recommendation would be to talk to your legal counsel, have them review your current lease agreement, kind of let them know about what these risks are that you're facing and what it is that you're trying to eliminate, and then have them go through it and advise from a legal standpoint, to what extent you can try and mitigate some of this. And then if there is any legal, action you can take via the lease, make sure that the language is as airtight as it can be. So that way, if you end up going into the courtroom in front of the judge and the plaintiffs are disputing that the agreement should be valid, that you make sure that you have the best defense possible to be able for it to have it hold up in court.
Great, thanks, Sarah. So coming back to then this discussion about what are the impacts of these lawsuits? What is the actual cost to the owner? And I'm assuming most of us on this call are looking at this through the owner's perspective. We work for owners, so when I say we're talking about standing in your shoes. But the costs can be very significant. So if we go back to that example that I made about the $100,000 in annual insurance cost as compared to that $900,000+ claim. Well, let's say that the insurance carrier there does offer renewal on the next policy term, but they're going to increase rates because of that one claim. Maybe they increase rates 30%, 40%, 100%. It's possible. And so you take that $100,000 in premium that maybe you've just been rocking along, each location pays its share, and then you double it. You're going to have buildings within the portfolio that don't necessarily cash flow as well as others. And they're going to see an increase in premium like that and go, wait a minute, where's the money for this? You'll be working with your property manager on that because they're worried about cash flow, or you're going to be obviously working within your management team because we've got cash flow issues for a particular partnership, a particular location. Having a renewal offer of coverage is really the best case scenario. Because it can also get worse than that, unfortunately, even with rate increases. So you'll see in this list possible non-renewal of coverage entirely. That means the carrier is not going to stick with you anymore. They've said, we had enough, we got hit on that claim or multiple claims, and we're not able to continue coverage. They have the right to do that. Once you get to the expiration date of that 12-month policy period, you've got to find a replacement. And we spend a lot of time working with clients. If they have experienced one habitability claim, it's not necessarily as bad as multiple habitability claims within a single portfolio. That's where it gets really ugly. Non-renewal of coverage means you're probably kicked out of the standard market because we assume that's where your coverage was in the first place. You're going to go into the non-standard market or the excess and surplus lines carriers. And right off the bat, probably paying double, maybe 150%, even a 200% increase in premium is not going to be unusual. And the coverage will have severe impairments. You're going to lose coverage likely, as to the second bullet point here, an exclusion of habitability coverage entirely from either the specific location that had had the claim in the past or even potentially the entire portfolio. Well, imagine how your organization would handle a $927,000 claim with no insurance coverage to backstop that whatsoever. It would be a disaster. It would be absolutely tragic to the organization, certainly to the particular location. So we want to, as much as possible, maintain habitability coverage for the bulk of the portfolio or if for the particular location, if at all possible. I mentioned the surcharge in rates there in the third bullet point, 25% or more. 25% is definitely the floor. It's often much higher than that. And again, definitely complicated by multiple habitability claims. One habitability claim, we can usually work through that when it comes to the next renewal of coverage and premiums and whatnot, but multiple habitability claims really, really start to cause problems for the portfolio. And finally, carrier reduction in available liability limit of coverage. So in particular, you probably are all familiar with the idea of having an umbrella policy or excess liability. So let's say over your portfolio of keeping it simple, let's say 10 locations, and you've got a $10 million umbrella policy. Guess what? That carrier on the next renewal might say, well, you had a $10 million limit last year, but this year we're only willing to give you $3 million. Yet you have lenders and investors out there that require you have 5 or 7 or 10. They're all over the map. And suddenly you're out of compliance with those requirements, which can be a real problem. Then we're going out to the market to buy non-standard excess liability coverage to satisfy those limits. And we're right back where we started with high costs of insurance. And I'll just close out this slide with one other point, that when you see these significant rate increases due to claims, I will say we have had lenders and investors also some municipalities actually come back and say, you know, we do not at all agree or support this increase in cost. It's unreasonable, and really push back on the fact that, you know, you were able to get insurance for the next year, and you know you've got a major rate increase, and now your partners on the building are saying, well, we're not going to sign off on this. And so if and when that kind of thing happens, it doesn't happen every time. A lot of times they do understand how the impact from these claims can be very significant, but it's still something to get ahead of so that they're prepared when your renewal comes around, so that you can hopefully smooth out those discussions and get everybody on board with the fact that we're doing everything we can to maintain coverage, and it does come at a higher cost. So I hope that's helpful, because it's one of those things that you can kind of plan ahead for. Let's see, I saw we had a couple of other questions come in real quick, so I'll touch on those before I turn it back over to Sarah. In the case of carrier reduction in coverage limits triggering non-compliance, yes, what are the consequences for the owner, and what recourse does the owner have if lender deems the portfolio to be out of compliance? Functionally, I would say the consequences, they're not earth-shattering. In most cases, we can talk with the lender. You know, in particular, my team, we know all the lenders and investors that you guys work with because we see them on multiple deals all the time. We can have usually a reasonable discussion with them, or get to a decision maker in the management level that, hey, here's why we're not able to comply right now. This is what we're going with instead. And usually it's cost driven, because the premium is so high. So if we have to go and buy those extra limits to get back to that required amount, sometimes they'll say, okay, we'll waive the requirement for this year, see how it looks next year. Therefore, you get to save those premium dollars. Or they say, too bad, you got to spend the money. But that's generally how it works. I would say more often than not, we come to some kind of compromise, but it's not without some worry on your end for sure, and some definite work to get to that point in the negotiation. And it's usually a management level. You may need to, you know, involve your executive team kind of thing, especially depending on your relationship with that particular lender or investor, because obviously that's a relationship you want to continue to foster and protect, especially if you have them on other deals. So we understand that too. But it's not the end of the world, but it does require a certain level of finesse for sure. And then the last question Susan sent, in the example, the owner paid the $393,000 in plaintiff legal, not the insurance carrier, correct? I believe that differential on that large claim was the defense legal, not the plaintiff legal. Sarah, would you speak to that just
Yes,
to be sure?
that's correct.
Yeah,
Yes,
so the
that's
defense legal is paid. Defense legal is paid. The plaintiff's attorney's fees, were those to be awarded, would not be paid. Hope that helps, Susan. Okay, I'll turn it over to Sarah.
So I know earlier we mentioned, carriers don't want to take these claims to trial because of the plaintiff attorney's fees, but another reason is just because it's very hard to defend at trial, especially in Los Angeles County. We actually were talking with a defense attorney because we wanted to know, who has won these cases, or successfully defended them, and what was it that they did, so that we can kind of use that as the blueprint moving forward. And the response we got back from the attorney was that he had never heard of a habitability case being successfully defended in Los Angeles. And so we kind of dug deeper into that to figure out what some of the factors were. And the main ones seem to be, first, jury bias. Typically, when there is a jury trial in Los Angeles, over half of the jurors are renters. As you guys know, there's a housing crisis. It's very expensive to get housing. Most people are renters. So there's a lot of sympathy that the jurors have for the plaintiffs. And then if the plaintiffs present well at trial, if they're extremely sympathetic, that could cause the jury to be biased towards them as well, and maybe stop looking at the facts so much, and paying more attention to the people. And, we asked, do you see a difference between for-profit housing versus affordable housing? Are jurors more sympathetic or more understanding for, landlords that are not for profit? And the answer we got was no. It's, even though, you guys are nonprofit organizations doing great work, it seems to be when it comes to these trials, or at least the ones that have gone to trial, it has made no difference for the jury. They still see it as a landlord versus tenant issue. And another big issue is that a lot of these cases are he said, she said arguments. So for those who don't know what that means, it's saying that the plaintiff is saying there's an uninhabitable condition, and then the owner or the property management company is going to say that that condition of the unit was habitable, and it's just going to be the plaintiff's word versus the defendant's word, and neither side really has a lot of solid documentation to substantiate their claims. So it just becomes an argument that is really hard to defend, and jurors tend to, at least in these types of cases, lean towards the plaintiff. And with habitability claims, the statute of limitations is 4 years in the state of California. That's a really long time. So if they said something happened 4 years ago and you don't have the documentation or the evidence to show that that thing didn't happen, you're likely going to end up in one of these he said, she said arguments. And then another issue is that it's just difficult for there to be nothing wrong with the tenant's unit. I mean, the building code section is so vast. Typically you guys are only inside of the tenant's units once, maybe at most, 4 times a year. And if the tenants aren't telling you about problems, if they're not communicating them to you guys, how are you even going to know it's there to be fixed? And also for issues like mold, for example, is a good one. Tenants complain about there being mold inside of their unit. But that can be really hard to prevent, especially if you have a property that's near the ocean, just with the marine layer coming in and the amount of moisture that's in the air. I mean, even brand new buildings you will go for and test, and there will be some type of mold. I've seen some claims that mention, deteriorated air quality in the unit. There's a problem with circulation. In California with, the amount of emissions and other environmental hazards, it's nearly impossible for there to be, purified, clean air in every single unit. So the chances of the tenants being able to find one issue in the entire code section that they can say occurred and have some type of substantiation to it is pretty high, because again, it's just so difficult for these units to be absolutely perfect and in line with the code section, especially when you guys don't have control over some of the issues. A really good example of that is bed bugs. You can bring in a vendor and you can try and treat every single unit in the apartment building to get rid of bed bugs. But if one tenant that has a bed bug problem is refusing to let the mitigation vendor in to do the bed bug treatments, or if tenants are continuously bringing in furniture that has bed bugs on it, there's really not much that you guys can do to control that problem. So next, we're going to actually talk about what it is that we can do to defend these claims. And while, the chances are that we can completely prevent these claims from occurring is low, as well as, the chances of us defending these claims in their entirety, there are things that as owners and property managers, we can do to establish a defense so that if a claim is made, the defense attorney can use a defense to potentially negotiate a lower settlement, perhaps get plaintiffs dropped off the case, save you guys money so that total cost incurred, that settlement amount is lower than it would be otherwise if we're in one of those he said, she said arguments. And I have seen claims where we do have a lot of solid documentation that the defense attorney was able to use and get a much lower settlement than what we typically see on average. So, these defense attorneys really need evidence to be able to back up our claim that a habitable unit was provided to the tenant. And really it just comes down to communicating with the tenants and documenting everything. Communicating with the tenants is good on a couple fronts. One, when you encourage them to communicate with you, you know what the problems are, you can fix them. When you're communicating back with them, you're building a relationship, you're building trust. Sometimes I find claims get filed, simply because a tenant isn't being heard. They feel like they have issues and no one's paying attention and they have to go to these lengths. So if you're making them feel heard, if you have a process to communicate with them, that can be a good mitigation tool. And then documenting everything. So, if you document every time a tenant makes a complaint, if you document every time a tenant calls in and you have those conversations on paper, you don't necessarily have to record these conversations, but, afterwards just have a call log filled out, or, have the property manager write down a blurb that summarizes what the conversation was. Those are things that we can do to show, whether or not a tenant actually made a complaint about a condition. And if they did, what we did, how we responded, how quickly we responded. And then, of course, if you do fix any issues, you want to make sure you document when they were fixed, how they were fixed. If a third-party vendor was brought in, you want to make sure you document when that vendor was out, what that vendor did. Even keep an invoice, keep a copy of the invoice. And if you try to fix it, and for example, if there's bed bugs and you tried to put in a mitigation vendor into a unit and the tenant simply refused, make sure you document their refusal. You document the notice that you sent them that you were going to enter. You document everything that you did to try and get that mitigation vendor into their unit. And if the tenant didn't allow that repair or that solution to occur, make sure you're documenting that. And that way we can try and establish what's called comparative negligence, which is where the defense attorney is going to be able to show the plaintiff's attorney, I know you're saying that these issues occurred. However, we tried to do X, Y, and Z, but we could not because your plaintiffs or perhaps other tenants in the building did not allow that to happen. So the next few slides are going to talk about actually developing policies and procedures for handling those tenant complaints. Like I mentioned, it's really important that these tenants feel heard and that when there's problems occurring in their units so that you can fix them timely before they become an even bigger problem and before the tenant feels like they need to go get other recourse, such as filing a lawsuit to be able to get changes done inside their unit. So make sure your buildings have a procedure for tenants to make work orders, to make complaints, and make sure they actually know about it and it's accessible. So whether it's, during the onboarding process, when you get a new tenant and, you're introducing them to the property, it's during tenant meetings that you host regularly, or during, your annual or semi-annual or quarterly unit inspections, make sure you're talking to plaintiffs and letting them know if they have issues, who they can make those complaints to and how they can make those complaints. So some examples are having a complaint box outside the manager's office, even having a form that tenants can complete. And then, again, make sure they know who to contact and how, so they have phone numbers and email addresses, so they know who they can contact when there's an issue. And then make sure when site staff receives those complaints, you have a procedure for them to respond. We recommend making it a requirement for them to respond within 5 working days of receipt or 5 business days, and make sure that the response is also in writing and kept on file. Like we mentioned earlier, documentation is important. Even if they end up calling the tenant to discuss, or they're talking to the tenant in person, you want to make sure the plan of action of what's going to be done to fix the complaint is put in writing to the tenant, and that we have a copy of that. And then in saying that, you want to make sure there is a written system to catalog every tenant complaint or request. So, you can actually keep copies of that within the tenant files themselves. You can have a separate file for all tenant complaints. You can even keep the documentation in both files, whatever, and it could be a different solution as well. It's every single property, every single operation is going to be different. Just make sure you have a system to document these communications with tenants. And so on the next slide, we talk about some additional written policies. You want to make sure, other than just communicating with tenants, you want to make sure you actually have a policy to correct repairs. If it's a critical repair that could cause severe harm. So an example would be if the front door to the building is supposed to be locked, and that's a security feature that the tenants expect, and for some reason the front door or that lock is broken, that would be a critical repair because that's a severe security threat. So that should be treated as critical. If a tenant is having leaks in their building and their unit and they're reporting that to you, water can quickly turn into mold. So you want to make, that would be another example of a critical repair. So our recommendation is to fix those critical repairs immediately, or as soon as possible, but to take no longer than 7 days or a week to get those done. And if it's a non-critical repair that isn't, going to lead to some type of a further loss or isn't a threat to the tenants, we recommend having those fixed within 30 days. That typically seems to be what's considered a reasonable time frame to make any type of repairs. Now, there could be instances where a tenant is making a complaint or they say there's an issue, but when you go to inspect it, there actually is no issue. There is no repair needed. Either the issue doesn't exist or, it's something that's so minor that there's really nothing you can do to repair it. So in those instances, if you go to investigate and no issue is found, make sure you tell the tenant and put it in writing what you did to determine that conclusion that there was no issue. And then, invite the tenant to come back to you with additional information. Let them know that if they feel that you may have missed something or that your investigation conclusions were incorrect, that they can always come back and provide more information to you and that you're willing to revisit it. What you don't want to do is ever close the door on the tenant, so to speak, and say, we looked at it, there's no problem, don't talk to us anymore about it. If there is no issue found, which I have seen before, again, let the tenant know how you reached that conclusion and then leave that door open. Let them know that if they feel that you were incorrect, have them come back and provide you with more information. And then just to make sure that site staff is actually responding and fixing these issues, we just recommend creating a calendar system that kind of raises an alarm if a critical problem hasn't been fixed within a week or if a non-critical problem hasn't been fixed in a month. And then finally, on the next slide, we're going to talk about if it's not corrected, if it can't be corrected within a week for critical repairs or within 30 days for non-critical, because there are times where it just can't be done. A really common example is if you need a specific vendor, such as an elevator vendor, and there's not that many in Los Angeles County, I know that, and you call them and you're willing to have them come out the next day to fix it, but not a single vendor can get out there until 35, 40 days later. You want to make sure you're giving written communications to those tenants. Let them know when you expect to be the issue corrected, when that vendor is going to come out. And you also want to make sure you're documenting those communications with those vendors, because if you're not documenting that and a tenant makes a complaint later against you and says, we made this complaint, it wasn't fixed until 45 days later, and you don't have documentation to substantiate that you tried everything that you could, that you called 4 different vendors, that none of them could come out, then we're going to be back into that he said, she said scenario. So do make sure if you run into an issue where it can't be fixed right away, that you are documenting that. And do remember, it's what a reasonable person, especially if this goes to court, that's what everyone's looking at. What would a reasonable person have done? So if you're able to show that you went to great lengths to try and get an issue fixed, it just simply couldn't be fixed, and you have good documentation of that, typically a reasonable person would be understanding. And then earlier, someone asked the question about if, you could still, if tenants could still ask for their rent to be returned if they're in low-income housing or not paying fair market value. And I did want to mention, so there is a civil code section. It's section 1941 through 1942, and it simply says that if violations or citations are found or made, they must be corrected within 35 days. If they're not corrected, the landlord cannot ask for or collect rent. So if you guys were cited by the Department of Public Health or there was a violation found with the building code and it wasn't corrected within 35 days, that code section says that you cannot ask for or collect rent. Again, it does not specify whether it's for market value, for-profit housing, or for affordable housing. So that would apply. There is also a fine that could be charged to the owner that could then be used to reimburse the tenant. So do keep that in mind. If a violation is found or if a citation is issued, that is a hard deadline. Again, there could be extenuating circumstances, but if you find yourself in those extenuating circumstances, you need to be even more cautious about how you're documenting that, so that if an issue or claim were to arise later, you'd be able to defend your position that you did everything you could to get that corrected within the 35-day window. And so in addition to, handling tenant complaints and having a procedure for that. We also want to talk about developing policies and procedures to actually document property conditions, which is on the next slide. And the reason why is to talk about those he said, she said claims where the tenant says there was a problem, you're saying that there is not a problem. And maybe, they didn't make a complaint. And if you do a good job of documenting that, perhaps we can show that no complaint was made. But another thing we can do is we as site staff, as property owners, as property management companies, you guys can go walk the properties daily, weekly, monthly, whatever your capacity is to do so, depending on the availability. And you can look for hazards or issues around the property and then fix them before anyone actually comes to you and makes that complaint. So you can identify them ahead of time, get a solution in place before this ever becomes an issue for the tenant. And we do recommend doing these types of inspections to look for hazards that could lead to, either bodily injury to one of the tenants or could lead to property damage, and make sure that you then have a plan in place to document if any issues are found and then get those corrected right away. We do recommend using a checklist when doing those types of walkthroughs to identify issues. One, it's a good way to document and show what it is that you're looking for, but it's also really helpful for new staff who may not be as familiar with the building, or perhaps they haven't, finished their training program yet. To give them a checklist of things to look for is a really great way to be able to have them go through the building with minimal training and be able to look for hazards or issues that could possibly be found. And we at Gallagher do have sample checklists for multi-family housing buildings. They're pretty extensive. They go through, the entire interior and exterior of the building, including common areas like fitness rooms and playgrounds. So, you will need to go through it and tailor it for each one of your buildings to make sure that it, it does directly apply. But please feel free to contact us if you guys would like a sample checklist that you could use. And then even if you go through the checklist and, you don't have to check every single item, but, at least showing what you're looking for. And if no hazards or issues are found, you don't want to just leave it and walk away. You want to make sure that you write a note on a log or write a note on the checklist somewhere that says, for example, we inspected the exterior and interior on such and such date and found no hazardous conditions. And that way, if, tenants are complaining that 3 years ago there were all of these issues with the building, you can go back through your inspection logs and show, no, we were checking these issues. We did not find anything. Here's the documentation that we have to prove that. Again, it's not necessarily going to make the case go away like magic, but it will be able to give at least us a defensible position and something in our corner that we can use to show that it was a habitable condition. And like we mentioned before, if any issues or concerns are found, make sure you eliminate them right away. Or if it's an unsafe condition, you want to make it safe. But if you can't fix it right away, make sure staff knows not to just leave it. Especially if they observe a leak and there's, a pool of water on the ground. If they can't get to that right away, they need to go, get some supplies. They need to go turn off, the water shutoff valve to stop the leak before they can mop it up, whatever it is. You don't just leave it. You put the caution wet sign up, you warn other people about the hazards, and then you go do the things that you need to do. Same thing, if you're walking through the stairwells and you see a loose railing or a broken step, and you know that you need to go get tools, or you need to call the maintenance staff, or you need to go get a vendor to fix it, don't ever just leave it, because chances are someone could potentially get hurt or there could be some type of damage. You want to make sure that you're actually warning people, whether it's putting up the caution sign, caution tape, putting a cone up, even just putting a sign up that warns people about it. And that way they can exercise reasonable caution and hopefully, avoid injuries. And in addition to the, just looking at common areas and interior and exterior, I know most affordable housing organizations do annual unit inspections. I know some do them more frequent. So I would encourage you to take a look at the checklist the property managers or site staff is using, kind of compare it to that building code section that we're concerned about with habitability claims, and make sure the checklist is checking for things that could potentially lead to a habitability claim. And then one thing I do recommend, if you're comfortable and you get approval of legal counsel, is to actually have the tenants sign their unit inspection forms. Because what ends up happening is you may do the unit inspection, everything looks great, tenant says everything looks great, 3 years later you get a habitability claim, they say their unit wasn't habitable. If we can go back and show, well, we were doing unit inspections, we didn't see any of these problems you're alleging, and you signed it attesting to the fact that there were none of those issues, that could give us documentation we could use to potentially defend the claim. So again, in addition to doing the common area inspections, think about your unit inspections as well. That could be another tool you use to get documentation. And I do have some of our affordable housing clients now that are having tenants sign their inspection forms, and I do think that that's a great idea to get something in writing where a tenant attests to the condition of their unit. And then in general, you know, doing these inspections, whether the common areas or the tenants, you know, if site staff's going around and they're fixing issues right away, if they're picking up trash, I find a lot of times that if a building is clean and running smoothly, tenants take a lot of pride in where they live in, and you may get buy-in from other tenants to be reporting problems, to be making sure that they themselves are keeping the building clean, and you can continue to build trust with your tenants that way by just maintaining that good building and showing them that you care and that you're looking for things to give them a safe and healthy living environment. And
Great,
now I'm just going to turn it back over to Robin. Yep, go ahead.
Yeah. So you all have sat here and listened to us talk about a lot of scary things. And fortunately or unfortunately, that's what we spend most of our day doing, is talking about those bad things that can come out and harm your organization, your building. But what we're really, you know, all on the same team to watch out for is protecting residents, protecting your organization and the assets. But the difficulty here is that the claim will eventually happen. It's one of those, not a matter of if, it's a matter of when. And these habitability lawsuits are not going away. They are getting more creative. Plaintiff attorneys are very creative. And guess what? They talk to each other too. And they share strategies. And they know where a particular organization or carrier may be vulnerable. And if it worked for one attorney over here, it might work for another one. And so they are going to, come at a lawsuit with as much strategy as they can, because again, if they're looking at potentially 2/3 of that award being for you know, their fees and costs, there's a lot of motivation for them. So what we've really tried to show you today is some realistic strategies to essentially build your defense before the claim happens. And you know, you may think that that's a bit of a cynical way of looking at things, but the reality is this is part of doing business in multifamily housing, and you need to be prepared. And I'm really quite appreciative of all of you that joined us today to get into this, because insurance is not always the most exciting topic for most people except us. And so we realize that it's a lot to really come out and hear this kind of discussion, but you're going to take away some really valuable ideas for defense and protecting your organization for the long haul. So Sarah mentioned earlier about, of course, document. We will continue to let you know how important that is. But she also mentioned about the 4-year statute of limitations. And definitely 4 years should, though, be considered the minimum amount of time that you maintain this documentation, because it's very, very often that the complaint doesn't actually come in until right before the statute runs out. That also happens a lot on bodily injury claims, which is a 2-year statute. And so you've got to maintain your records, because we really will then need to go back in time and reconstruct all of the, you know, potential repairs, requests for repairs, how was it handled, what was communicated, did the resident refuse to allow us into the unit, you name it. We need to be able to reconstruct that. And so keep that documentation for definitely longer than 4 years. And I also want to just point out that whether you're working with a third-party property management vendor or you have in-house property management, you probably have run into the same difficulty, which is information that exists at the site doesn't always make its way to your office. to your main headquarters, to the asset manager, or to the CFO, whomever is really responsible for overseeing those high level insurance and claims types discussions within your organization. You must be sure that you've established that flow of communication from the site staff to the office, and that that information is shared so that it's available, that it can be saved, or in the event that, you know, we need to call that information up, that we can actually get it. And too often there are written notes, actual hard copy written notes at the building in a notebook that nobody can find. And that doesn't help you defend the claim. You need that information to be, is some protocol sent to your office and maintained, ideally in an electronic format as well, so it can be recalled easily. Our next,
One quick
and
thing,
actually
Robin,
I did also, go ahead, Sarah.
I almost forgot to mention, I'll make this quick. If you guys are using vendors to fix any issues, or if you are, you know, for example, are bringing in a bed bug vendor to, you know, try and mitigate some pest infestation issues, do make sure you're entering into written agreements with those vendors that are having them indemnify or hold you guys harmless from any claims that arise from their work. You know, so for example, if you came in to have the bed bug treater treat the units, this issue didn't get any better. I have seen cases in habitability claims where we've actually been able to pull in third-party vendors as co-defendants. Now, we can't transfer the entire claim away because they're usually so broad, but the more defendants that we're able to pull in because of those contractual requirements just kind of spreads that risk out, and kind of takes some of those dollars that have to be paid out under your policy. It can transfer that risk to their policy. So I strongly recommend you always enter into a written agreement, make sure that it's in your favor, and that you keep copies of those agreements and the certificates of insurance, so that way if the claim does arise, we could potentially transfer some of that risk and bring in other third parties to help.
Great, thank you. Yes, and that's definitely critical. If we've got a vendor who was supposed to eliminate the problem and they didn't, then we need to know who to go to for at least maybe a portion of that claim. I want to acknowledge just a couple of comments. Chris made a comment about California being a tenant-friendly state. I think that's a pretty common perception, certainly from the insurance carrier's perspective. That's why many of these do settle. Again, building your defense file, if you will, of documentation is critical. And really that is also going to dash the hopes of the plaintiff attorney when they see they have found a building which actually does have good documentation and is going to fight them on the claim. Suddenly they don't see as many dollar signs as they saw before, because they're going to have to work really hard to try to get something out of your insurance carrier. And so we want to put up that line of defense to let that plaintiff counsel know it's going to be harder than you think. This is not easy money, and we're not just going to surrender a blank check to you. I see that there's a question from Jesse about physical inspections. How much lead time is required to inspect the interior of units? Do you recommend annual or quarterly for tenant unit quarterly inspections? Definitely, Jesse. I think it's important to have more lead time than even is, you know, kind of required by law. So let's say if it's 24 hours is the minimum notice period, I think it's totally reasonable to give 2 or 3 business days. I think that it's always better to give a little bit extra time, but certainly look to your law in the jurisdiction. And if you have access to your real estate counsel, which usually you should, then make sure you've run that past them to be sure you're in compliance. In terms of annual or quarterly inspections, quarterly would be great, especially if your portfolio has other habitability claims. Certainly we want to eliminate them from happening at all, but if you've got one, you need to consider that now your organization is probably on the short list of targets, and you might get another one sooner than you think. So the more frequent inspections you can have, the better. And again, to reiterate Sarah's point about having the resident sign off on the inspection, that's fantastic strategy if you can get it. The comment from Steve about indemnification clauses in security contracts. What levels are appropriate? I'm assuming by levels, Steve, you mean limits of coverage. So I'll just kind of make that assumption as I answer your question. With security contracts, we want certainly basic levels of general liability insurance, but even higher excess liability, maybe a few $1 million, 3, 4, even 5, depending on the building, kind of what the scope of work for the security contractor is. And also certainly, will they be armed or not? And you need to have that conversation with your insurance carrier through your broker, because sometimes if you have armed guards, you don't have coverage for that. And that's not a place you want to be. So you need to be sure that you're upfront and transparent about that. But I would say definitely the 1 million, 2 million basic general liability limits, and then let's say at least another couple million for excess liability on top of that. But again, it's going to depend on the circumstances for your particular building and the scope of work there. Great. So I think our next slide is the very colorful alphabet slide, which I can't take credit for this. This is Sarah's slide, but I got to steal it and talk about it because I am the documentation nag. Always be careful and document everything. It's true. And I think you've gotten that loud and clear today. Document absolutely everything. It's just critical. And memories fade. He said, she said becomes a real problem. But if we've got it in black and white, that's something that can actually be used to defend a claim. So here's your quick mind trick, A, B, C, D, E. Always be careful and document everything. Now on the next slide, we want to talk just a little bit more about if that claim actually occurs, how can we help your defense attorney in the onset? Well, obviously, providing them with copies of tenant files and communications with tenants. Certainly, if that tenant has become a plaintiff actually in a suit and you've been served and everything, you want to have all of that available. Work orders from the alleged time period, citations that the property may have received and proof of those corrections that you've made, records of any treatment, bed bugs, mold, rodent infestation, remediation, and that kind of thing. The contracts with those vendors, whether it's a bed bug remediation vendor, a mold remediation vendor, property manager, plumber, those contracts are critical. The property's policies and procedures to maintain a habitable building, again, many of which we've given you some suggestions today about, and then common area and unit inspection reports during that alleged time period. And again, it's entirely likely, I would say it's 99.9% likely that the time period alleged in the lawsuit when you receive it is going to be the full 4 years. 4 years of time when, maybe none of you actually worked for the organization during that time, and the people that were the site managers are no longer around with the organization anymore, and the property management firm has changed twice since then or something. It can be very difficult to reconstruct. That's why I say the information needs to flow to the office. It needs to make it to the owner's office and not only live at the site or only live with the property manager. And finally, before we kind of sum things up for additional questions, and then we're going to turn the mic around to you for a little bit. If the claim occurs, you also, on the next slide, we talk about need to be aware of retaliation claims. So this is a new issue that's becoming more frequent. And the goal, of course, is to increase the settlement value of the claim. So if you receive the summons and complaint and the lawsuit, it's in your hands, what they're alleging, at least from the onset. And you've got that list of all those plaintiff names, and there can be many. You don't need to do anything to aggravate the situation. If anything, we need to be on a proactive path to de-escalation. So nothing outside your normal policies and procedures without consulting with your attorney first. In most cases, you're going to have an attorney assigned from your insurance carrier within a few days, maybe a week at the most. You're going to have someone guiding you, and you need to listen to their advice, and you need to work with them, and you need to allow them the ability to help protect your property and help protect your organization. And finally, please do not send an eviction notice without consulting with your attorney first, even if they're late on rent or you would otherwise evict them for, a legitimate reason. It really complicates things if there's an eviction notice outstanding. And we have definitely seen many situations where there's a difficult resident involved in one of these claims, and we have seen times when the owner thought, okay, well, here's an opportunity to move them out, and that's not necessarily the best path. We want to be sure that we're, defending the claim and we're acting reasonably. So those are just a couple of things to watch out for, because it's not too difficult to be baited into a bad decision when it comes to potential retaliation or claim of retaliation. So with that, I want to just wrap us up to any additional questions. I'll check the chat here. What have I missed? Oh, I think that's it so far. If there's any other questions, and then we're going to pose a couple of questions back to all of you. So I'll just pause for a moment. I don't think I've missed anything, Olivia or Jeanette. Let me know if you see otherwise. So go ahead. Anything?
It looks like Chris did make a comment about they take a lot of pictures inside of the units as well as the exterior all the time, and I think that's a great point. A picture is worth 1,000 words. So if you are taking pictures to show the condition of the unit, that can go a very, very long way. It's a great point.
Yes, thank you, Sarah. I appreciate you catching that, because that's absolutely true. And as I like to say, there's no excuse not to have those pictures, because everyone has a camera in their pocket all the time. We all do. So then I'd like to turn us to our final substantive slide, which is apply what you have learned. What else can be done? And this is where I'm really looking for some feedback from you about what you've learned today and the best strategies to defend a claim. So what else might be done to reduce the impact of habitability claims on nonprofit affordable housing? Because obviously that's what we're primarily representing here. So nonprofit affordable housing and protecting against these claims. In other words, you all are serving a mission and working very hard to provide housing, quality housing, safe, with, in many cases, services. Do you have any other ideas about how we might reduce this impact of habitability claims on nonprofit affordable housing? And then also next steps that you might recommend or take yourself to reduce the likelihood and severity of habitability claims. And I'll just pause and kind of watch the Q&A, or I'm not sure if we have people able to unmute themselves, Jeanette, but happy to take questions that way too.
They're not able to unmute themselves, so it's just through the Q&A.
Okay. So don't all answer at once. But love your feedback on reducing the impact of habitability claims on nonprofit affordable housing, or other steps you might recommend or take yourself to reduce the likelihood and severity of claims. Oh, thanks, Jesse. Jesse's been paying attention. Document, document, document. Yes. And then some. Certainly. Well, while all of you are typing your responses, let's see, documentation, Steve says, documentation of not just repairs, but efforts in cases that take more time to cure, certainly. Let's see. Oh, and I see some other, lots of pictures from June, says lots of pictures. I'm sorry, I'm not able to see all of those comments for some reason. Jeanette, I'm not sure if you're able to pull up. I see some comments coming just to the panelists, and for some reason I'm not able to see those separately. Oh, maybe I just found it.
Yeah, they're in the chat box.
Okay, apologize. I found them. Lots of pictures. Communication with tenants to establish trust and relationships. That's exactly right. That's really, really important to, as Sarah said, sometimes people just want to be heard. Let them know how much you care. It's probably in your mission statement, how much you care. You all believe in that. You know, you wouldn't be working in nonprofit housing if you didn't. And so showing people that you care, imagine the difference that could make for someone who is approached by a plaintiff attorney, solicited by them to join the class action lawsuit, and they say, well, wait a minute, my landlord does take care of me. They do care about me. You know, no way, I'm not going in on this. And that's great. And maybe they'll tell their friends, hey, this is a racket. You don't want to be part of that. We have great landlords. We love where we live, you know, having pride in where they live. Exterminating logs for all services performed at the properties. Absolutely. Thank you, Patrick. And then Jessica made a comment about communication is key. Pictures back up all of the that's reported. So take as many as you can. Again, we know your phones have lots of storage. You can take lots of pictures. Have an attorney review your lease. Correct, Susan, that's right. In light of including attorney's fees limits. Exactly. That's very true. And then I want to see if I missed anything else. One other, maintain properties and conduct inspections frequently, as well as documentation. Yes, that's true. I want to offer one other idea, and then certainly Sarah probably has additional feedback too. Another idea that we have really spent some time over the last few years talking about is engaging with legislative partners to potentially provide protections for nonprofit affordable housing developers. That would separate you from the market rate for-profit developers, but isn't there potentially a way to provide some additional protection, maybe a mandatory time to cure a hazard or alleged hazard, for example? I don't have the roadmap to get us to that point, but I wanted to pose that idea and see if anyone had any feedback about a possible legislative partnership or solution. Any ideas on that? In the meantime, Sarah, if we can watch and see if we get any other comments back on that idea, I'm happy to turn it over to you to see if you have any other final points before we close out on the various questions we've gotten and whatnot.
Yeah, I think we did miss one question in the chat that was not sure if this was answered already, but what if the resident is the one who made the unit unhabitable? So we do see that from time to time. And like with everything else, what we need to do is document those conditions. So when you're going through the unit inspections, make sure you're documenting what they were. You know, if it's the tenant's responsibility, that you show that you communicated to them, whether that's, you know, just through an informal written communication, or whether you're actually sending them a formal notice that they're not in compliance with their lease. I know, you know, hoarding and other things like that can lead to rodent and pest infestations, as well as some other habitable issues. If you do see issues like that inside of tenants' units, especially for those of you out there that use social services either in-house or contracted out, make sure you're talking with those social service providers, letting them know about the issue, so that they can help support those tenants in getting their units to be cleaner and in a better living condition. Make sure that's all being documented. The photos is a great idea. If you're documenting issues on the site inspection checklist that shows what the tenants have been doing, of course you can have them sign that to attest to the fact that they were the ones who caused those issues. And again, one we see a lot is tenants just refusing to allow maintenance staff in to make repairs, and tenants refusing to allow third-party vendors in to treat the units. And so if you are experiencing those issues, I mentioned it earlier, but just make sure you note that you gave the tenant notice, that you tried to enter the unit, they refused to let you in the unit, and document that entire process. That way we're able to establish that you guys did everything you could in your power as owners and property managers, but unfortunately they were not allowing you to do that. And that's what we call that comparative negligence, is being able to establish that those uninhabitable conditions were actually caused by the tenant and not caused by you, the property owner. So I hope that answers the question.
Great, thank you, Sarah. And I apologize, I did miss that in the chat, so I appreciate you catching it. That will then conclude our discussion points for today. I just want to reiterate that we hope you document everything. And Sarah and I are always ready, willing, and able to assist you with any questions that may come up. Our email addresses are on the final slide of today's presentation. And finally, I would encourage you, as you go back to your next team meeting or management check-in, what have you, that you look at a couple of things. What are we doing to protect against habitability claims coming in? Have we had any in the past? Have we learned from it? And also, is this something you even have coverage for? It's worth double checking so that you've at least got an idea of the ability of your organization to transfer this risk away to an insurance carrier, or if that coverage has been eliminated in your insurance program and you don't really know it even. Because as you can see, it can be very costly, and it's not at all unusual. We used some pretty significant examples on both ends of the spectrum today for claim costs, not quite $100,000 claim versus an almost $1 million claim. But it's very typical for these claims to run $300,000, $400,000, $500,000 in expense when you put together the settlement, the defense costs, and what have you. And claims like that are going to have a significant impact on your insurance premiums and, frankly, your relationship with your standard market insurance carrier. And the most important thing is protecting your insurance program and really the cost of insurance to your individual building. So we thank you so much for the time today. Hopefully this was very helpful for you. And again, Sarah and I are always available if you have any other questions would like to reach out. And thanks so much for logging on today.